This Honorable Court of Tennessee is now in session. Please be seated.
Good afternoon to everyone. We want to welcome you to the Tennessee Court of Appeals. The panel for this afternoon is Judge Frison to my right, Judge Davis to my left, and myself, Judge McClarity. Parties have been situated. Mr. Clerk, is there any preliminary matters before we get started?
No, Your Honor.
Okay. In that case, will you call the first case, please?
Yes, sir. Loveday Springs et al. V. Knox County, Tennessee et al.
Yes, sir. Have you reserved, or do you want to reserve any time
I have, Your Honor.
for rebuttal?
We have reserved 5 minutes for.
5 minutes for rebuttal? Okay. Then you may proceed.
Good afternoon, Your Honors, and may it please the Court. Daniel Sanders here on behalf of the petitioners, Loveday Springs. This appeal turns on a very simple and purely legal issue. And that is, does Tennessee Code Annotated 137101A authorize Knox County to impose conditions when it rezones a piece of property? Because the answer is no, the rezoning at issue in this case was illegal, and the trial court erred in granting summary judgment to the defendants.
Mr. Sanders, would you care to pull your microphone up just a little?
Apologize.
Perfect. Thank you.
Our position is simple. Conditional zoning is not authorized under Tennessee Code Annotated 137101A. The legislature's enactment of 137101B proves it, and no amount of rational basis analysis can transform an unauthorized decision into a lawful one. At bottom, this case is about the rule of law. Local governments have only the delegated authority given to them by the state. The court's familiar with the rule stated in Edwards versus Allen. The state delegates zoning authority to local governments, which must act in accordance with that authority. The Edwards court framed that issue as one of jurisdiction. In that case, the local body violated a mandatory procedural safeguard. In this case, Knox County has ceded its delegated substantive authority, and our position is that the decision should be the same. Those decisions should be void and of no effect. Any consideration of a statute and interpretation of a statute should begin with the language of the statute. The court's been provided with that ad nauseum in the briefing. 137101 sets out the general county enabling legislation for zoning. Subsection A does the bulk of that work, and the plaintiffs, in this case, will concede that that language is broad. In fact, if you were to read that language in a vacuum, it would be difficult to say that the counties don't have conditional zoning authority. However, as the court's well aware, you don't read subsection A in a vacuum. You have to read that statute together as a whole, and that's a general rule of statutory construction. We're not arguing here that this part of the code in one title should be read in connection with part of the code in another title. You only have to read a few lines down from subsection A to get to subsection B, and that is the operative language here. We know that subsection A doesn't include the authority to zone property conditionally because subsection B expressly authorizes certain counties to engage in conditional and contract zoning. The operative language there is those counties within a certain population bracket are further authorized and empowered to rezone properties conditionally or based upon contract. And there's some additional language that follows, but that's essentially it. When you read subsection A together with subsection B, the conclusion is inescapable. The legislature knew how to do what it did in subsection B. The word conditionally does not appear anywhere in subsection A, and therefore counties that are not within the population bracket do not have that authority. We have, I was remarking earlier that that it's a simple statutory construction case, and I believe that it is, but the parties have attack that from various angles. And so we think that it violates several canons of statutory construction, and those, the Tennessee Supreme Court went through those canons in Falls versus Goins, which is a 2023 case, a very recent case, and sort of went through the litany of canons, and I think this case violates every one of them. One of those is the courts must give effect to every word. Well, if we see that subsection B says conditional zoning and subsection A doesn't, we give effect to that in subsection B and see that it's not in subsection A, and we can't give that authority in subsection A to those counties.
Counsel, excuse me for interrupting. Could you address the effect or impact of the Odell decision on this
Sure.
case?
Sure, and so I would say the Copeland, Benton, Odell trilogy, I refer to those three cases together because they sort of percolate up through Odell, right? Odell, we assert, was a case about contract zoning. And when it arrived at the Court of Appeals, number one, the Court of Appeals said, big caveat to begin with, we're not even sure that the party has standing to bring this case. With that said, it was about contract zoning, and the trial court found that there wasn't contract zoning, and we agree with the trial court. Now, what happened was the Court of Appeals essentially copied and pasted the trial court's decision into the Court of Appeals' opinion. And if you read through that in serial, you see that the conclusion that it wasn't contract zoning is borne out in the first part of that opinion. When the court ruled, that was the essential part of, I think, the trial court's ruling, that it wasn't contract zoning. The court then went on to say, it's not contract zoning, it's conditional zoning. And I would think that every part of the decision after that would be dicta, and we've argued that in our brief. What he did then was to say, there are two cases, both of them out of Chattanooga, Copeland and Benton, and they're both post subsection B, what I'll call post subsection B cases. There is 13.7.101, which is the county zoning enabling legislation. 13.7.201 is the analog municipal enabling legislation. It contains a subsection A and a subsection B virtually identical to those in the county enabling legislation. And so the court in Copeland and the court in Benton said point blank, the city of Chattanooga is authorized to engage in conditional zoning because it's authorized under 13.7.201B. And the Court of Appeal of the trial court in Odell latched onto that, did not grapple with the statutory language, and proceeded to say essentially that conditional zoning doesn't offend the general principles of law in Tennessee like contract zoning does, and relying on precedent that said contract zoning was potentially unconstitutional. And so we would assert, Your Honor, that Odell is not on point because it involved contract zoning and not conditional zoning. Number two, the statements about conditional zoning in Odell, number one, they referenced cases out of Chattanooga where a municipality was specifically authorized, and they shouldn't be read as a broad adoption of that conditional zoning throughout the state. We have analyzed the broader scheme of enabling legislation for zoning to argue that our construction of the statute is consistent with the broader scheme. We have drawn the court's attention to the uniformity requirement in section 13.7.102, and in this case, the conditions that were imposed, which were essentially a density condition, a phasing condition, and condition that actually removed part of the enacted zoning ordinance that would allow clustering of units on a piece of property. Now, I don't know that I can make sense of that. The zoning ordinance allows clustering. The condition removed that condition. I don't know. I think it's just more evidence that what they did was sort of incoherent. We've also drawn the court's attention to the amendment process, 13.7.105. Counties have to go through a process to amend the zoning ordinance, and this is tied into the uniformity requirement. If counties are able to engage in this ad hoc procedure of rezoning property subject to conditions, they essentially are able to create a zoning district that is a one-off zoning district that doesn't have anything to do or no uniformity with other places in the county where the zoning district applies. And so it makes the map, and I want to make this point, it leads to a lack of enforceability because you have to go back through the minutes of a county commission meeting to determine what regulations apply to each particular parcel. You might have I see that my time is
Yeah, your time is
expired.
up. You have your time for rebuttal left, though. Yes, sir.
May it please the court, my name is Garrett Swartwood. I'm here on behalf of the appellee Thunder Mountain Properties. With me at council table is Mr. Mike Moyers, who's here on behalf of Knox County. And if the court will indulge us, I'd like to argue for a portion of our time and then yield the balance of my time to Mr. Moyers to make some comments on behalf of the county.
How many minutes do you want versus how many minutes he's going to get?
We didn't come to a firm agreement, Your Honor, but perhaps if you can give me 10 minutes and Mr. Moyers 5. I'm not saying my argument will be twice as important as his, but that seems like a fair balance.
10 and 5? Okay,
Thank you, Your Honor.
go right ahead.
Your Honor, the appellants effectively are asking this court to overrule 50 years of case law that has approved the idea of conditional zoning by local governments in the state of Tennessee. And they're doing that on the basis of virtually no authority whatsoever. The only authority that's been addressed by the appellants is this one statute, Tennessee Code Annotated 13.7.101B, which expressly doesn't apply to Knox County. It applies apparently only to Hamilton County. So based on a statute that doesn't apply to Knox County, the appellants are asking this court to overturn multiple cases in which this court has found that local governments have the authority to conditionally, to place conditions when rezoning properties. Now, the argument that somehow brings in this statute that doesn't apply to Knox County in the first place is the expression expressio unius est exclusio alterius. And don't ask me to repeat that, please. But this exclusion rule of construction. And I think that rule typically applies when a statute has a list of items that are described, and the court interprets that list as being exclusive of anything else. And you don't have that situation here. So it's really kind of a stretch to bring in a statute under that theory. The theory really doesn't apply to the statute, and the statute expressly doesn't apply to Knox County. What this court is left with is a long history of case law that affirmatively recognizes the right of local governments to conditionally rezone property. And because that case law is so important, I do want to go over some of those cases with the court. I know they're in our brief, but I think it's important to kind of lump them together because what you see is a series of cases that span both time and geography, that are both before that statute was enacted and after that statute was enacted, and it creates a very firm jurisprudence related to this topic that the court should be aware of. And the first case is not one of the two cases from Chattanooga that council referred to. The first case is the Hayman versus City of Chattanooga. I don't think that Hayman case is referred to in the appellant's briefing at all. I'm not sure it is. But Hayman is very important because of all these cases, it's the one case that predated the enactment of that subsection B in the statute that the appellants rely upon. That subsection was enacted in 1984, and Hayman was decided in 1973. Now, Hayman was a case that involved contract zoning, and there's no argument that contract zoning applies here. This is clearly a case of conditional zoning, not contract zoning. But in a footnote, the Hayman court recognized that nothing in this opinion is to be construed as holding that a planning commission without a covenant cannot prescribe reasonable conditions for the benefit of the general public. That's in a footnote, and counsel would probably argue it's dicta, and I'd agree. It probably is dicta at that moment in time in the Hayman decision. But that language and that concept that the local government has the authority to conditionally rezone property continues throughout a series of other cases. So the next case in this series is the Benton case. And Benton is one, I think the first one after the enactment of that subsection B. So Benton takes that footnote and quotes it in the body of its decision. And Benton, I think for the first time, expressly states that the authority to rezone property conditionally is inherent in the general law of the state of Tennessee. And specifically, the quote from that case that's important, and this was a quote of the trial court that was adopted by the appellate court, was that the general law, as the court has noted, authorizes conditional zoning, which was done in this case. So now you've got a case both before and after subsection B was enacted, both recognizing that outside of that statute, there is inherent in the general law of the state of Tennessee the right of a local government to place conditions on rezoning property. Now, the one thing that Benton does not do, and Hayman does not do, and the subsequent case of Copeland does not do, is explain what's the source of that authority. And so I come to the fourth case after Copeland, which is the Odell decision that Judge Frierson asked about. And Odell is very important. I think Odell is effectively on point legally. I mean, the facts are obviously different, but the legal issue in Odell is the same issue that appears in this case. The decision in Odell is not merely dicta. Odell decided, in fact, that what happened there was not contract zoning, but it was conditional zoning. So the finding that it was conditional zoning was not put in a footnote as dicta, and the effect of conditional zoning was not some footnoted item. It was a major part of the decision in which the court found that conditional zoning was proper. Now, Odell refers back to both Benton and Copeland, which are these Chattanooga cases. But both Benton and Copeland recognize that there is in the state of Tennessee an inherent power of local governments to impose conditions on the rezoning of property. And I think maybe for the first time of all these cases, Odell expresses the source of that power, which is the police power of the state. So counsel would argue, look, you can go through these statutes, and nothing in the statute says you can conditionally zone, and that's true. I mean, I've not found anything in the statutory body that says you can conditionally zone, and it's true that Knox County takes its authority to rezone property from the statutory body. But once it's given that authority, this court has recognized over and over again that local governments have certain police power to enforce the laws in a way that most benefit the citizens of the community. And that's what this court recognized in Odell. In Odell, the court said that the cities, this was Johnson City, the city's imposition of conditions as a requirement of rezoning were reasonable and were a valid exercise of their police power for the good of the general public. Excuse me. So what you find in this series of cases is both before and after the enactment of the statute, the court has recognized that the city or that the county has the police power to impose conditions for the benefit of the citizens. The reasonable exercise of that police power is not questioned in this court. It is simply a matter of whether we have the right to conditionally zone in the first place. I think there's some irony in the fact that these conditions in the exercise of the police power of the local government are imposed for the benefit of the citizens, especially those surrounding this community. And it's those citizens that opposing counsel purports to represent and challenging the very conditions which were enacted for their benefit. So, I'm not sure if the court can simply overturn these conditions without harming those same members of the community. But in any event, it's clear from the case law that the court has the county has the power to impose these conditions, and there's no basis that's been presented to this court to overturn that 50 years of case law history. I still have another minute or so, but unless the court has any questions, I'll turn over the rest of my time to Mr. Moyers.
I hear none. Thank you,
Thank
sir.
Good afternoon.
Yes, sir.
Very briefly, I wanted to just emphasize a couple of things. First of all, the Hayman decision, again, I think is crucial because it does recognize in that footnote an inherent power to conditional zoning that pre-existed that statute. Now, if Mr. Sanders is correct and the statute limits conditional zoning to Hamilton County / Chattanooga, then the legislature has done something that I have to question whether they intended to do. If the power to conditionally zone was inherent, it meant it existed in all 95 counties, at least so far as they've enacted zoning. If he's correct, not only did the legislature give it to Chattanooga, they took it away from all 94 counties, and I doubt very much that was their intent. But I wanted to mention one thing about Benton quickly. Benton really was not, or I think the import of Benton was not that it was a question of contract versus conditional zoning. In Benton, the plaintiff challenged the constitutionality of 137101B on the basis of Article 11, Section 8 of the Tennessee Constitution, general laws only to be passed. The Court of Appeals sidestepped that challenge because it found that there was no contract zoning here. They found it was conditional zoning, and that conditional zoning was consistent with general law. If Mr. Sanders was correct, Benton was decided incorrectly, because if Hamilton County is the only county that can do conditional zoning, then the entirety of the statute would be suspect under Article 11, Section 8 of the Tennessee Constitution. So Mr. Sanders is asking you to overrule Benton versus Chattanooga. Odell has been spoken about, and I would just echo what my friend Mr. Swartwood said about that. We don't need to speak any further about it, but except to say that, again, in arguing that only Chattanooga has that power, Mr. Sanders is asking the court to overrule Odell, because Odell cannot be properly decided if only Chattanooga has that authority. And finally, there's a case that didn't make it into anybody's brief, and I apologize, but I just found it this morning. It's Citizens for Safety and Clean Air versus City of Clinton. That's a case 434 Southwest 2nd 122. Some people might remember this as a 2013 case. It's not that old. In this case, there was an annexation challenge. We haven't seen any of those in a while, but this was decided when that was still a thing. And the city of Chattanooga, or Anderson County and the city of Clinton and another entity entered into an agreement that if Anderson County dropped their challenge to this annexation of a piece of property that was anticipated to be used for a quarry, in which the community did not want to act as a quarry, that if Clinton decided to rezone the property, there would have to be certain conditions placed on the operation of a quarry. And that's what happened. Now, when this case came up, the citizens argued it was contract zoning. They'd negotiated this. But this court, said no. The city of Clinton is not required to rezone the property. It can or cannot. It still has that complete discretion to do. But if it does, it's agreed to certain conditions for the operation of the quarry. That's conditional zoning. That's not Hamilton County. That's not even Johnson City. That's right next door in Anderson County in 2013. Mr. Sanders is asking you to reverse this case as well. Because if he's correct, this was conditional zoning that would be illegal. And the Court of Appeals found it was valid. So I agree with Mr. Swartwood that
Is that case in your brief?
I'm sorry?
Is that case in your brief?
It was not, Your Honor. I apologize. I didn't find it till this morning. As I was doing some last-minute prep for this, I just wanted to make the court aware of it. It is a reported
If you want
case.
us to consider it,
I'm sorry?
if you want us to consider it, you'll need to send a copy to us.
Okay.
With no argument. Also, you need to CC your adversary.
I will be happy to do that. Thank you, Your Honor. Anyway, the point I'm trying to make here with all of this is that Mr. Sanders is asking this court to reverse 3 of its own decisions to come to the conclusion he wishes to reach. I think that's improper. I don't think that the adoption of this statute did or was intended to claw away from all 94 counties in the state of Tennessee the power to do conditional zoning, which was recognized in the Hayman case. And therefore, we would ask you to uphold the trial court in this case and dismiss the appeal. Thank you.
Okay. Thank you very much. Your rebuttal, sir?
Thank you, Your Honor. The defendants here are asserting that, he's not started my time yet, so they're asserting that we want to overrule 50 years of precedent. I don't know that that's the case. In fact, I think Odell is distinguishable. I think Copeland, I think Benton, those were properly decided because they specifically say the city of Chattanooga is authorized under the municipal analog 201B to engage in conditional zoning. I'm not asking the court to overrule those cases. I am asking the court to look to the ultimate authority, which is the language of the statute in this case. The statutory language is the authority that we rely on here. So when the defendants say that we've cited no authority, that's the primary authority. And the court knows that the ultimate job that we have of interpreting statutes is to give effect to the intent of the legislature. We don't pick the idea that conditional zoning is permissible in the state of Tennessee in a general abstract way. The question is, has the state authorized localities to engage in what might otherwise be permissible? And the answer is no. In the context of zoning, local governments are not simply exercising broad police powers in the abstract. They are exercising authority that has been delegated through the zoning enabling legislation. Edwards was clear, when you act in that circumstance, in that sphere of authority, you have to follow the rules. And although conditional zoning might be generally acceptable, when the legislature has said, here is your authority in subsection A, and then here is a further authorization and empowerment to certain counties in subsection B, we need to read that with the regular rules of statutory construction and find that subsection A does not include what is expressly included in subsection B. Again, Hayman, the footnote, we're not asking the court to overrule that. If the legislature wanted to turn around and say in subsection A, yeah, counties are generally now authorized to engage in conditional zoning, they might take the part of subsection B that's already there and move it up into subsection A, then our argument falls apart, right? I'm not asking the court to overrule Odell. I think Odell, when you get to the fact that it wasn't contract zoning, at some level, the court has to decide the issues that are put to them by the parties. And the Court of Appeals was clear, the trial court was clear, that the plaintiff in that case only raised the issue of contract zoning and not conditional zoning. If the party had raised conditional zoning and engaged the language of the statute in that way, the court would have been confronted with the language of subsection B juxtaposed with the language of subsection A. And maybe the parties would have spent more time grappling with what exactly Copeland and Benton say, right? And it would appear that, even the trial court in that case sort of arrived at those cases on its own in doing the research to sort of, bookend his opinion that this wasn't contract zoning. They say that nothing in the statutory body says conditional zoning is inappropriate. Again, it's not a question of whether it is generally permissible in an abstract way. It's whether the legislature has reduced that to a delegation of authority, and that's really what we're dealing with here. I am not familiar with this Citizens for Safe Clean Air. I do read the TBA every day, so I probably read it when it came out, but it didn't register with me, probably because this is an annexation case, and it doesn't sound from Mr. Moyer's recitation of that case that they actually made it to a rezoning, right? If devil's in the details, I think, and so we'll have to look at the language of that case to see if it was actually a zoning case or a annexation case, and whether that statement about conditional zoning was dicta. I have nothing further. If the court has any questions, I'll be happy to.
I hear none. Thank you very much. I want to thank both of the parties for your presentation. Your case now has been submitted to this court for resolution. You should receive our opinion and a judgment within a reasonable period of time. Thank you both.